Okay, thanks very much for joining this webinar this afternoon. We're going to be looking at what Brexit means for GDPR and non-UK businesses. My original intention was to focus on the non-UK business part, but there's quite a few people from the UK joining as well. So I'm going to cover both. I also hoped that when I set this up or scheduled this, I don't know, 2 or 3, maybe even a month, 2 or 3 weeks or maybe a month ago, that we might have some clarity, because Boris was saying that Brexit needed to be sorted by mid-October. The EU was saying by mid-November, and here we are on the 17th of November, and we're still waiting to find out what the outcome of the EU Brexit, UK-EU Brexit agreement looks like. Probably at this point, one of the things that's worth just pointing out is that GDPR obviously has implications. That's why you've joined this webinar and why I'm running the session, and that those GDPR implications are probably all tied up within the bigger Brexit agreement bundle. So if they don't sort out the trade agreements, and certainly recently a Brexit expert was saying to me that everything is tied up within one agreement. So if there is a problem in reaching an agreement in one particular area, then the other areas are likely to suffer as well. So at the moment, we still don't know whether we're going to have a no deal or a deal Brexit, in the sense of knowing what that's going to mean from a GDPR. So I will talk through that with that understanding. My intention, as I say, was setting it around now, was that we probably have a clearer understanding about what's going on. But yeah, I'll touch on that as we go through. So for those who don't know me, my name's Mark Gracey. I support businesses with their GDPR compliance. I do that through a range of different support helplines and services, from acting as a data protection officer to carrying out audits and providing a GDPR helpline. My background actually goes back to when the 1998 Act came into force, and I've been working with businesses on GDPR since it was published in 2016. But I'll talk a little bit more about the business and how I can help you towards the end. So we're going to have a quick introduction to what GDPR means for international or restricted transfers and where the Brexit factor fits into that. Look at what Brexit means if you're a business in the UK, a business outside the UK, and what that actually means in practice for now, in terms of making decisions about what you might want to do next. And I take on board completely what I was saying before about the fact that we don't actually know whether we're going to get a GDPR agreement in place, let alone a Brexit agreement. So there's quite a few question marks in most of this presentation, and what you do next will depend on whether you want to leave it to the last minute or start thinking about or putting things in place. And I know from working with some of the clients that I'm working with, they are erring on the side of let's get everything in place ready for a no-deal Brexit. And if there's sort of no harm done if a deal is struck, but at the moment it's difficult to know what that deal might look like. And then hopefully we'll have some Q&A time at the end. So let's set the scene with a quick overview of GDPR and where restricted transfers fit into that. So this is a slide that I often use, which is kind of a potted summary of GDPR. It covers the full range of what GDPR is about. Of course, data protection is all about the protection of personal data. We have principles which set out the rules around that processing of, around the processing of personal data. All processing has to be lawful, so there's a set of lawful basis which applies. The individuals whose data is being processed, the data subjects, have rights, those individuals' rights, and the GDPR introduced a new principle. So it is a principle, but I gave it a separate bubble on its own because it's quite a wide set of rules. is the principle of accountability. So that's proving that you're doing the right thing and having some proper checks and balances in place. And indeed, I think it was last week, I ran a webinar about the accountability framework, which is a new framework from the Information Commissioner's Office, the ICO, the UK's regulator, about how to interpret certain elements of the accountability principle. But today we're talking about Brexit, and therefore that means we need to understand the basics around non-EU processing, and that kind of fits in as a data protection principle, although in GDPR terms it's not defined as a principle as it used to be under old data protection, but it's in the GDPR nonetheless. So there are a set of rules around processing data outside the European Economic Area. And those rules are essentially, you can process data inside Europe. So if you're in France and you want to process your data in Germany, you can do that and you don't have to do any checks and balances. Otherwise, you have to look at whether there are any adequacy decisions, any appropriate safeguards, or any exemptions. Now, adequacy decisions is basically the EU Commission approves countries' data protection regimes as being appropriate and compliant with the principles of GDPR. So they're equivalent to GDPR. So that means if you process your data outside of Europe in one of the countries where there is equivalence or an adequacy decision in place, then it's okay to do that. You don't need any other checks and balances. I've listed there pretty much, I think, all of the current adequacy decisions, and that's Andorra, Argentina, Faroe Islands, Guernsey, Israel, Isle of Man, Jersey, New Zealand, Switzerland, Uruguay, plus Canada and Japan, but there is with under limited circumstances, and those circumstances are usually within the context of business processing. Japan's the most recent. I think it took a couple of years for the EU to approve Japan's data protection laws as being adequate. And so if a country wishes to prove its adequacy, it has to go through this, quite a lot of hoop jumping through with the EU Commission to make sure that the EU Commission are happy. If there isn't an adequacy decision, and you'll notice that some of the most probably common non-European Economic Area countries that are likely to be processing data, like United States, India, for call centers, that kind of thing, and China, aren't in that list because they don't have an adequacy decision. So if the country is not within Europe, it doesn't have an adequacy decision. The sort of the final step, apart from some of the exemptions, I'm not going to go into the exemptions in detail, but there are some exemptions like explicit consent, so you have to process it under the contract and the contract's been agreed, and some other examples like public interest. If there is no adequacy decision, there's no exemption, the country is not within Europe or within the European Economic Area, then you have to rely on what's called appropriate safeguard. Now, I've listed the EU Privacy Shield in red with a line through it because some of you might have heard about the Privacy Shield. It used to be an arrangement between the EU and the US that if a US company signs up to Privacy Shield, then the company is signing up to the standards of data protection. And the view is that if an American company, even though it's a self-certification process, misuses the data, the US government will take some form of enforcement. And there's been some challenges in the past about whether that is an effective way. And the Trump administration was being challenged that it hadn't done enough to protect European citizens' data by Facebook with Cambridge Analytica and things like that. And then finally, in the summer this year, a European court declared that Privacy Shield was actually invalid because the US government has laws for national security, which essentially trump any other agreement that might be in place between a European organization and a US organization that was using Privacy Shield. So Privacy Shield is now invalid and you can no longer rely on Privacy Shield as an appropriate safeguard. It's worth listing in it, and the reason I listed it still, even though it's highlighted in red with a line through it, is because there are lots of things going on at the moment to try and work out what the next steps are. there is rumour that the EU are talking to the US to try and sort out Privacy Shield, and maybe we end up with a son of Privacy Shield or Privacy Shield 2.0 or something. But at the moment, we're not too sure. But I'm not going to get too much into the detail of that. But if you want to ask me questions at the end, then feel free to do so. So Privacy Shield is no longer an option. The most common appropriate safeguard is to use standard contract clauses. Now, the SEC, or model clauses as they're sometimes called, are basically non-negotiable contract terms that have to be literally cut and paste from an EU regulation. So you're essentially binding both the exporter and the importer. So if you're in the European Economic Area and you're exporting to, say, America, because you're using an American company to do some processing, or the data is being moved and stored in the US, for example, then you can use the standard contract clauses to bind both parties to European standards of data protection. And the indication or the expectation is that these standard contract clauses allow you to basically provide sufficient protections and also allow the data subject, the individual whose data it is that's being transferred, to have a kind of right to redress should there be any particular issues. Now, for the same reason the Privacy Shield has been deemed invalid, which is national security law in US, entitles the US government to ask US providers to hand over data, there is also some question around standard contract clauses. And at the moment, we're expected to carry out due diligence on on these third parties, particularly in the US, but anywhere where we rely on standard contract clauses, and carry out a risk assessment. What that risk assessment is and what we're supposed to be risk assessing against is not particularly clear. But just briefly as an aside, the EU have done two things recently, or within the EU, there's been two things happening. One is the European Data Protection Board has published a 6-step regime of things to consider. It's a draft, so it's not a formal approved document at the moment, but these 6 steps are ways in which EU organisations can check to see whether or sort of put in extra safeguards in addition to using the standard contract clauses to ensure that the standard contract clauses are legitimate and lawful, and that you're carrying out this risk assessment. The European Commission has also published some updated standard contract clauses, which actually address some additional challenges, because the standard contract clauses as they are today are between controller and controller, or controller and processor, and there are no others around that. And there's recognition that actually organizations may be processors and using a sub-processor in a non-European economic country. So there are businesses, for example, who outsource their work to agencies in India, for example, or China. And so the European Commission are addressing that, and that's kind of, I guess, driven by the Privacy Shield as well. So there's still some things to come on that, and when things are a bit clearer, then look out for a webinar, because I'm sure I'll be running a webinar to sort of look at what the outcome of what is globally referred to as Schrems 2, because it was a case that was raised by Maximin in Schrems, a privacy advocate in Europe. So that was a slight aside, but it's quite an important area to understand. There are also some other contractual terms that you can use. So there's binding corporate rules, which is if you transfer data outside the European Economic Area because another part of your business is in outside the European Economic Area, like you might have a parent company based in the States or something, then you can have these internal binding corporate rules, but these have to be improved by the ICO. So most people tend to most organizations use the standard contract clauses instead. And there is an option for, in the UK, for example, the Information Commissioner's Office or the statutory authority in whatever European country you may be in, to come up with a code of practice or a certification scheme which you can follow, which governs the relationship of between EEA organisations processing data outside the EEA. So why is this important? Where does this Brexit fit into this? Well, the importance is in understanding that at the end of the transition period, the Brexit transition period that we're currently in, which ends on the 31st of December this year, so from the 1st of January next year, the UK will obviously no longer be part of the European Economic Area, and depending on the outcome of the the EU trade talks and the debate between the UK government and the EU, that will determine whether we are seen as essentially processing data, or organisations in Europe will be seen as processing data outside of Europe or the economic area if they process data in the UK. So this is kind of the background of understanding that there are certain processing activities which lead to what's called a restricted transfer to a country outside the EEA, which is referred to as a third country. So appropriate safeguards is probably the key element. Of course, where Brexit fits into this, we'll cover as we go through, but there's a lot of uncertainties I've already said. Now, there's another element to be considered, and this is another part of GDPR, which is the element of territorial scope and how data relating to EU citizens is covered when it is being processed outside of Europe by organisations that are based outside of Europe. And so this is the territorial scope. So it's quite widely known that GDPR has extraterritorial reach, which means that whilst it applies to all member states across Europe, and that includes the UK right now until the end of the transition period, it also applies to organisations outside the European Economic Area, like organisations and businesses in the US, India, China, or anywhere else outside the European Economic Area. And there are certain things that have to apply if you are outside the European Economic Area. So if you're a non-European business, GDPR applies to you when you're processing the data of individuals, and you will need a European representative, which could be that you have an office in Europe, or if you don't have an office in Europe, then you have to appoint somebody to act as your representative within the EU, and that typically will be an organisation. I think certainly a lot that I've seen have been sort of law firms and specialist EU representatives in the country where you typically have the bulk of your customers. So this only applies for individuals, not business to business. But if you're outside Europe and you're targeting European individuals, you will need an EU representative. You will also, so just one thing on that representative, just to put it in some context. So you may or may not know that a lot of the big US sort of Silicon Valley businesses like Facebook and Google, etc., have offices in Dublin. So that's their EU representative is their office in Dublin, essentially, which has introduced some interesting challenges for the Irish regulator, who has suddenly found that they, because of this territorial scope issue, have had a lot of challenges put their way, much more than they would have done in the past, because of these big US organisations basically basing themselves out of Dublin. And in fact, the Schrems 2 case, which is the lead to invalidating a privacy shield I was talking about earlier, that was instigated through the Irish regulator because Facebook has European headquarters in Dublin. So that's EU representatives. There's also the concept of a lead supervisory authority. So, and a good example of this is actually the British Airways case, which you may have seen was enforced by the Information Commissioner's Office in the last couple of weeks. There was a cybersecurity issue where basically somebody was able to essentially hack the British Airways website and redirect payment details to a third party. So basically people booking tickets with BA over this period of time when their website was compromised were also sending their details to a third party, including things like the security code and number and expiry date and everything that you could use externally without any kind of, you can shop online with that information if you had it. It wasn't just UK people who were affected by this, there were other Europeans. So as British Airways is British, and because there were UK citizens involved, the lead supervisory authority for that particular case was the Information Commissioner's Office. So what it means is that if a breach occurs across the whole of Europe, a lead authority takes charge and therefore that European entity or that business is not answerable to multiple equivalents of the ICO across the different jurisdictions in the different member states. And that's the concept of a one-stop shop. So if you are having dealings in the UK, France and Germany, and you cause an issue which has an impact on UK, France and Germany, or UK based, you're likely to use have the Information Commissioner appointed as your lead supervisory authority, who will act on behalf of the UK, France and Germany as well. Businesses outside of Europe don't have that, don't necessarily have that opportunity. So there is a potential that if you're outside of Europe, you could be answerable to multiple authorities if you cause multiple member state systems to suffer harm or not being compliant. And so that's the concept of one-stop shop and appointing a lead authority. So outside of Europe, you don't have that luxury. Essentially, companies like I was saying about Facebook and having their representative being their organisational European headquarters in Dublin means that the focus for them is the Irish regulator. But you wouldn't have a choice. You can't claim that if you're in the US and you're a US business that you wish to be applying US law by a US representative. It would to be within the EU. So you don't necessarily get that one-stop shop or have a clarity around who the lead supervisory authority is unless you have a particularly strong presence in the country. So let's get down to what this all means for Brexit. So what Brexit means for GDPR is that from 1st of January 2021, there will be a UK GDPR. So we'll probably end up talking about EU GDPR and UK GDPR, which on paper will amount to the same thing. And we, of course, have the Data Protection Act 2018. Whether that gets updated or not, it's not entirely clear at this point. But the key thing from a Brexit point of view is that we will be seen as what, as I said before, as a third country. So that means that there is any processing in the UK by non-UK businesses would be seen as a restricted transfer if those non-UK businesses were in Europe. And then there are other connotations depending on where in the world you are and whether you're targeting UK citizens or not. And that's the next few slides addresses that from all those different angles. But the key questions here really is, are we going to see adequacy decisions? So, going back to this slide, will we get an adequacy decision? Will the EU declare that UK GDPR is the same as EU GDPR? We've been living with GDPR since 2018, so it would seem common sense that the approach would be that, of course, that is indeed the case. But there's a few flies in the ointment that might cause some challenges. The EU have already suggested that other elements of data-related legislation implemented in the UK may not be in line with European thinking, and that may be a reason why the EU might not give us an adequacy decision. There was some, most recently, I think it was roughly around the same time that the controversial new bill was being discussed around Brexit, and they also published, the UK government published a national data strategy about being a global leader in the data economy, and some questions around whether data protection law needed to be changed. And of course, the EU said, well, hang on a minute, what does that actually mean in reality? So there's all these little things which could add up to there being a problem with being given adequacy. But there's also this bigger picture of whether we get a deal or we don't. And if there isn't a deal, then we probably won't have an adequacy decision unless an agreement is put together sort of outside of the main EU-UK Brexit agreement and deal. There's some questions around whether we can benefit from the one-stop shop. Again, that might come down to adequacy. That could come down to an agreement between the UK and the EU. And it will also bring questions around whether UK organisations who target individuals in Europe will also need to have an EU representative. So they'll be answerable to the UK regulator because they're UK businesses, but because they may infringe the rights and freedoms of data subjects in a member state, say France, then they may also be answerable to CNIL, which is the French equivalent of the Information Commissioner's Office, and therefore be answerable to the ICO and to the French regulator and possibly the German regulator. So there is this question about whether the one-stop shop can be sorted out. And it could also mean that if you have more customers on the continent in France than you do in Germany, then you would also need to have a representative representing you in France, unless you've got an office based in the in a European member state. So a lot of this outcome of what this will actually mean in reality really comes down to whether we get a deal or not, and that can be looked at in two ways. One is the general Brexit deal that we hear about in the news and is, I think, being debated this week between the European Commission and between the EU and Boris's team. But there's also that, well, from a GDPR point of view, that could potentially be a deal that's struck or not struck. And that could or could not lead to adequacy, a decision on one-stop shop and a decision on EU representatives. So really the rules on what data flows and what I'm going to show you in the next few slides could potentially change. And the next few slides are really sort of looking at this from a probably no deal GDPR Brexit, as it were. But a lot of those data flows and what you can and can't do is going to come down to whatever deal is reached, whether that's a Brexit deal or a specific thing around GDPR between the EU and the UK. So what does this actually mean in terms of data flows? So if you're in the UK GDPR will apply, the Data Protection Act 2018 will apply, or anything that may be, maybe some supplementary things added to that. And the Information Commissioner's Office will be your regulator. So just as they have been since the 1998 Act came into play, the ICO will be the regulator, and everybody in the UK will be answerable to the ICO. If you do UK business, if you're a UK business doing UK business only, so you're not selling services, so I used the term targeting before, so that's basically selling services or products to European citizens, then you will probably not see any change. Just that the legislation may be called slightly different, like UK GDPR rather than the GDPR. When we will be talking, as I say, probably about UK GDPR and EU GDPR, but they will essentially be the same. So if you're a UK only business, not doing any business with individuals in Europe, you're purely a UK business selling and delivering your service within the UK, then you're not likely to need to do anything different. If, however, you are offering services and products to EU citizens, so individuals, not business to business isn't included in that, and my understanding is it's all about the individuals, then you may also need an EU representative. And that could be an office that you have in Europe, or appointing somebody in one of the member states where you have most European customers to be your EU representative. As I said before, whether that becomes reality or not will depend on any agreement that's reached. We may no longer be able to rely on a one-stop shop. So, as I said, the UK only, nothing changes. This is for businesses that have operations that work with European citizens and other people around the world, but operate from the UK, but may be processing data outside the UK, or of people outside the UK. If you're one of those organisations, then you may not be able to rely on the one-stop shop. So you could potentially be answerable to multiple regulators, like the Information Commissioner's Office in the UK. But what is clear is that the UK to European economic data flows are not restricted. So so let's use a CRM, a customer relationship management system hosted in the cloud, because of the wider definition of processing, including storing as well as editing, deleting, manipulating, and using it for the purpose you have it in the first place, is considered processing. Because of that wider definition of processing, let's say you have a CRM which is hosted in France, so use a French provider, you store your data on a server in France or maybe in Dublin, you are therefore passing, your data flow is going from the UK to a European Economic Area country, and there will be no changes. So the UK is essentially saying, we trust that Europeans are applying GDPR because it's a European regulation. If you're processing your data outside of the European Economic Area from the UK, so maybe you're a UK business and your CRM is hosted in the US, for example, or you're using Dropbox to store your spreadsheet of customer data, your data will be hosted and therefore processed in the US, and the UK government has indicated that it will follow the lead of the EU. So if the EU says there's an adequacy decision with New Zealand, then there's essentially the UK will say that they also will rely on that adequacy decision to say it's okay to process your data in New Zealand. Likewise with the standard contract clauses, and the expectation is, for example, that going forward, nothing will change in that area than it is today. If you process your data in the US today, you would have to have these standard contract clauses in place. Some questions about what the Schrems 2 case means, but you would have these standard contract clauses in place. And going forward, after the transition, if there's a no deal, or even if there is a deal, actually, excuse me, the intention is that you will continue to use standard contract clauses. Now, what will be interesting is that these new clauses that I mentioned are being discussed at the moment. There's some questions about what that actually will mean in reality. If that's a EU regulation, will the UK government have to say you have to use these new ones or whatever? We'll have to see about that. But generally speaking, the same appropriate safeguard approach for UK to non-UK or non-European Economic Area processes will be the same as it is today. If you are, however, and this is where the next slide comes in, if you're a European controller, so that's the organisation who's collecting and processing the data that's been collected, and you're relying on the UK to do the processing. So say you're a French company and you use a CRM developed by a business in the UK and the data is hosted within the UK, then that will be a restricted transfer because the UK will not be part of the European Economic Area anymore, and unless, of course, an agreement is reached, in which case the EU to UK data flows will be restricted. So what does this mean in practice for essentially European businesses? They will, of course, have European GDPR as they have right now and as we have right now. EU businesses doing business with EU organisations or processing data in other EU member states, there is no change. It's okay to process data in different EU countries. They will also be able to rely on the existing standard contract clauses, the appropriate safeguards, adequacy decisions as we do right now. They will obviously continue to do that. Now, interestingly, the UK government has indicated that if you are an EU business and you are basically offering products and services to UK citizens, just like a UK business offering services and products to EU citizens, you'll have to have a representative, but this way, the other way around. So you'd have to have one in the UK. So that essentially means that a company in France who is selling products and services to individuals in the UK, if they don't have a UK office, will need a UK representative, so somebody representing them in the UK from a GDPR perspective. I should have said when I mentioned it before, these representatives are essentially there to be the person on the ground in the member state as it is now, or if there's a UK one, then in the UK, to represent the organisation in that country. And there's an indication that actually some of the representatives could be held responsible as well if there was a breach or some particular issue. So, but I think in reality that's probably unlikely. But if you're an EU business and you are doing business with individuals in the UK, you could end up needing to have a UK representative, which could also ultimately mean potentially you'll be answerable to not only your EU regulator where you're based, but also the ICO as well in the UK. As I said, UK to EEA data flow. So if you're a UK business processing data in Europe, that will continue to be okay. But if you're a EU to a UK data flow, so you're an EU business using a UK data processor, then you will be doing a restricted transfer, which means you need to make sure an appropriate safeguard is in place, which will typically be a standard contract clause. So if you're a UK business and you have EU clients who ask you to process their data for them, like a marketing company perhaps, then you can expect that your EU clients may be asking you to sign new contracts, which include the standard contract clauses, and then potentially with these new ones that have been drafted recently for consultation, another set in maybe a year or so's time to tie in with that. So you need to be mindful of that. Now, in terms of the rest of the world, in the UK, we will, as I said, we'll have our own GDPR and the Data Protection Act. If you're just like an EU company selling products and services to a UK citizen, you will have to have a UK representative may be needed. So that means that whilst Facebook has a headquarters in Ireland, which means that their EU representative is in Dublin, they will potentially, because that's where the headquarters are, they will potentially also need to have one in the UK as well. I know they have offices in the UK, whether that's how they do it, I don't know, but potentially they will need a UK representative, as will anybody outside the European Economic Area that is selling products and services to UK citizens. And they could be answerable to the ICO for non-compliance. And as I said before on the first slide, if you're in the UK and you're processing data outside the European Economic Area, then the current rules as seen by the EU with regards to what is and isn't a restricted transfer will apply. So in essence, what I'm saying is, doesn't matter where in the world you are, Brexit is going to have some kind of implication. If you're on the continent and you're doing processing in the UK, or you're targeting UK citizens, then you are likely to have to do some work. If it's the other way around, you're in the UK and you're processing data in the EU, then you have to do less work, but you could end up with having multiple representatives in the UK and in the EU in terms of making sure that you're compliant as well. So in all things are pivoting on there being an agreement, and whether that's a Brexit agreement or a separate GDPR related agreement will determine what you need to do. But at the moment, it's not looking likely that this will all be sorted out in time. And if you consider the fact that Japan's adequacy decision, for example, took a couple of years to get sorted, if they have to go through the same timescales with the UK, then we're not likely to see that in the next month and a half. So from the 1st of January next year, if you're in a UK business, you need to think about the implications of what that means should we go down the no deal route. And if you're a non-UK business, there's also implications as well. So what now? What does this actually mean in terms of what you should be thinking about? Well, I think the key thing, if you're a UK business, then you need to keep an eye out and keep your ear to the ground, your eye on the ICO's website, your eye on the UK government's website in terms of what's happening with the EU Brexit deal, to make sure that you know by the end of the year what you're doing. How much you want to do before then is really up to you. Are you going to go for a last minute dash of getting everything in place once it's a bit more clearer, or are you going to put things in place at the moment, sooner rather than later? So that means if you're a UK business, you might want to sort out standard contract clauses for your European customers so that they don't have to worry about it and you've got control over that whole mechanism and so forth. But essentially, keep your eye out for what's going on. There's only, what, 6 months to the end of the year? Sorry, 6 weeks even. It's only about 6 weeks to the end of the year. So hopefully in that 6 weeks, we're going to know what's going on. It's important that you pay attention to that and understand how that could impact you. Make sure you understand where in the world your data is being processed, which you should be doing anyway, because you have a GDPR obligation to have a record of processing activity, or a ROPA, as the ICO like to call it. Identify which documents and policies you might need to update, particularly if they need to reflect not European GDPR, but UK GDPR, and say something about how you deal with data processes and the such. Identify whether you need any standard contract clauses in place with your clients and talk to them about it. Work out whether you need an EU representative and be prepared to work out who you're going to go with if you do need one. But potentially be ready to act last minute, because it might be a last minute thing that we find out the outcome of it all. So you might want to get a plan in place, which is essentially what this slide represents. Now, if you're a non-UK business, and apologies, the title on this slide still says UK businesses. If you're a non-UK business, again, you need to keep an eye out what's you're being told. So the EU do publish memos about their expectations, and the last one said, prepare for a no-deal Brexit. So you need to keep an eye out for that. You also need to understand what the UK government and the ICO are saying about things like whether you need a representative in the UK. So understand if your data is being processed in the UK, or whether you're selling products and services to individuals in the UK. Work out what you're going to do if you might need a UK representative. If you're an EU business, then you're going to have to think about how you put standard contract clauses in place for any UK processes. And again, you're probably going to need to act at the last minute, or at least put some preparation in play, get a plan of action for how you want to deal with this over the next month and a half. So that's pretty much what I was going to say for this afternoon. I hope that makes sense and not too complicated. I mean, I think if there's a takeaway from this, it's we don't really know what's going on. I did hope that we would have a bit of clarity by now, but that doesn't appear to be the case. Everybody will need to do something, no matter where in the world they are. What that will look like is going to fall out in the next 6 weeks. If it doesn't fall out in the next 6 weeks, then I guess there'll be some transition periods for GDPR compliance in the new year, but we don't really know right now. So if you need some help and assistance with this, then that's exactly what I do. I am working with businesses at the moment about what they need to put in place for contingency planning for Brexit, no matter what it might look like. Some businesses are already being told by their customers that they want them to be getting standard contract clauses in place, and so forth. If you need a standard contract review because you don't know whether it's a standard contract clause or somebody's sort of trying to pull the wool over your eyes and adding in extra liability and other things, then yeah, get in touch. And I've got a product and a service that I can help you with that, and yeah, give you any kind of help that you need. Which takes us to questions. We've got about 12 minutes for questions.